So good morning, good afternoon, and good evening. Welcome everyone to this week's session of Law as Science. I am Marilyn Haj, SJD candidate at UVA School of Law. I will serve as your moderator for this session. Before turning to today's esteemed speaker, Jonathan Choi, let me briefly introduce the Law as Science project. Law as Science is an academic initiative coordinated by a group of JSD candidates from across the United States who share the same belief in legal methodologies. Legal methodologies are often understood as a discipline distinct from sciences, traditionally consisting of doctrinal analysis and normative questions. Through this series of interdisciplinary talks, we aim to show that legal research can be improved and benefit from scientific methodologies that provide systematic ways to approach questions. If you want to learn more about the Law as Science project, please visit our website and join our email list. One of our awesome coordinators will drop the links in the chat, so stay tuned. And speaking of our coordinators, I would like to take a moment to introduce the team. We've got Simon Sun, who's a JSD candidate at Indiana University Maurer School of Law, and he's the co-founder of the initiative. We've got Daniel Hafke, a JSD candidate tuning in from Germany, who's at Cornell Law. We've got Vanessa Villanueva, a senior fellow here at Law as Science and the chief editor of our blog, The Legal Method Lab. And we've got a host of representatives from diverse law schools in the US, like Berkeley, UPenn, University of Illinois, Georgetown, University of Washington, Columbia, and Fordham. So if you're interested in getting involved, we're always looking for new Law as Science representatives. We also host a blog on legal methodology. We call it The Legal Method Lab. And we're always on the lookout for new editors, or if you think you have an interesting piece and you would like us to highlight it, please contact us. So enough with the shameless marketing. Let's turn to today's speaker. Jonathan H. Choi is a professor of law at USC Gould School of Law. He specializes in law and artificial intelligence, applying natural language processing to study legal issues. He also specializes in tax law and statutory interpretation. His work has appeared in the New York University Law Review, the Stanford Law Review, the Yale Journal on Regulation, and the Yale Law Journal, among others. His work has been covered by a wide variety of news outlets, including ABC News, CBS, CNN, Fox News, NBC Nightly News, The New Yorker, The Washington Post, etc. Choi graduated summa cum laude from Dartmouth College with a triple major in computer science, economics, and philosophy, and earned high honors for his computer science thesis. He earned a JD at the Yale Law School, where he was the executive Blue Book editor of the Yale Law Journal and a founding co-director of the Yale Journal on Regulation Online. Before entering academia, he practiced tax law at Wachtell, Lipton, Rosen, and Katz in New York. He previously taught at the University of Minnesota Law School. In today's talk, Professor Choi will delve into his current project, exploring the Supreme Court's use of Canon over more than 2 centuries. This aligns seamlessly with our mission here at Law and Science, as Professor Choi pioneers the application of innovative methodologies to advance legal research. In this paper, he and his co-author employ cutting-edge natural language processing (NLP) tools, drawing inspiration from computer science literature, particularly utilizing what is known as large language models, LLMs. Up until this point, I'm going to be honest, I just thought LLMs were the master students at my law school. So it's very useful, and it's broadening my horizon to hear about studies like this one. We're really looking forward to discussing these methodologies further with you. And on a very final note, we're going to have a Q&A segment at the end of the session. So please stay with us till the end, prepare some questions. We look forward to a tantalizing conversation with you. Without further ado, Professor Choi, the floor is yours.
Well, thank you very much, Marilyn, and thank you to the organizers for inviting me to give this talk today. I'm excited to share some of my work with you. This work represents part of my broader research agenda and a broader movement within empirical legal scholarship to use natural language processing to conduct the kind of research that previously would have had to be done by hand. So the improvements in large language models, you may have heard of things like ChatGPT or Gemini from Google and Claude from Anthropic, over the past really couple of years has made it possible to conduct analysis at scale that would have been just impossible to do before because it would have taken so many human coders. You would have had to hire an army of RAs or an army of professors. So now there's an opportunity to do a really new kind of research, and there's a lot of low-hanging fruit out there. So in addition to talking about my specific project, what I'm hoping to do is present some general methodologies that are relatively straightforward to use, that follow the, I think, growing consensus among computer scientists and empirical researchers that actually just using an off-the-shelf large language model can produce quite good results, in many cases, better results than doing something more laborious, like, traditional random forests, like vectorization methodologies, and even then fine-tuning large language models that are publicly available. So it's actually quite easy to use, and you can get really interesting results by doing so. So let me give a brief overview of what I'll talk about over the next few minutes. I'll tell you what canons of statutory interpretation are. I know for an international crowd, you may not be familiar with these. Statutory interpretation plays a different role in the United States than it does in other countries. I'll talk about our methodology in studying canons of statutory interpretation, and I'll talk about some cursory initial results. As I note in the paper that was distributed online, we're still conducting exploratory analysis. We haven't pre-registered and committed to our hypotheses and methods yet. We're still soliciting feedback. So if you have any feedback, that would be really appreciated. Okay, so first, what are canons of statutory interpretation? Let me situate this in broader debates over statutory interpretation in the United States today. So in the US, there's been a dramatic rise in what's known as textualist interpretation over the past few decades. This is driven by scholars and jurists like Justice Scalia, as well as a new crop of generally conservative-leaning justices like Justice Barrett, Justice Gorsuch, Justice Kavanaugh. Most of the conservative justices lean toward textualism. Now, one potential issue with textualism is that text as written by legislatures is not always entirely clear, especially in the cases that get to the Supreme Court. And in those cases, it can be really helpful to have a rule or a background norm or kind of a tiebreaker that will help you to resolve close cases when the statute remains ambiguous after ordinary principles of statutory textual interpretation have been applied. So increasingly, textualists have turned to canons of construction, which are principles, rules, presumptions, or maxims used to resolve or address questions of statutory meaning. This is the definition we came up with based on famous writing by Scalia, Garner, Eskridge, Sutherland, a lot of luminaries in this space. There isn't a universally agreed on single definition, and in fact, as we'll see later on, it can actually be a little bit tricky to pin down what is and isn't a canon of statutory interpretation. So here are some examples of statutory interpretation canons. One is the Expressio Unius canon. Many of these canons have Latin names, especially ones that pertain to how to read language. So this says Congress's choice to say X suggests that Congress meant to exclude Y. So if Congress passes a statute saying lions, tigers, and bears are not allowed in the park, the Expressio Unius canon says, well, it's ambiguous whether hyenas are allowed in the park. So because Congress explicitly said lions, tigers, and bears and didn't say hyenas, hyenas are pretty similar. So we'll assume they meant to exclude hyenas. So hyenas are allowed in the park. That's one example. Another example is the rule of lenity. This is what's known as a substantive canon. So it takes a substantive position rather than a position about how to interpret text. And this just says ambiguity in a statute defining a crime should be resolved in the defendant's favor. And there are a lot of historical precedents for this. There is a historical belief that if law is vague, that shouldn't be held against defendants. You shouldn't be thrown in jail based on an ambiguity. So these are both examples of different kinds of canons, both textual, language, and substantive canons. Now, one difficulty we had in defining what a canon is that there are a lot of things that courts say that could be taken as rule-like, presumption-like, maxim-like, but that are not well-known canons of statutory interpretation. So if the court says, we generally interpret statutes so as to support the taxation of municipalities. That's a broad general statement. That's not really a canon I've heard of, but we decided to include these because these are statements of general applicability. On the flip side, there are cases where a court will say something that reflects canon-like reasoning, but is very specific. So if the court says, not that Congress's choice to say X suggests that Congress meant to exclude Y, but specifically talks about lions, tigers, bears, and hyenas, that's not a statement of general applicability. That, it turns out, is very hard to separate from ordinary judicial reasoning. Almost any item of analysis that a court conducts could be turned into a statute in some way, but it's very difficult to separate these from, just general common sense or ordinary judicial logic. And so what we focus on in this paper are statements of general applicability. So things that apply not just in this case, but in all similar statutory interpretation cases, which is a methodological decision. That means that it's a little narrower than, for example, the study conducted by my co-author, Nina Mendelsohn, but it does capture something distinctive about the nature of canon reasoning. So existing literature in this space generally has focused on hand coding for specific canons. So canons are quite complicated. They're difficult to analyze using traditional natural language processing tools, and therefore generally they've been analyzed by hand, by reading a lot of cases and manually writing down where canons were present. And that means that you either need to limit yourself to very specific canons, like employment law canons, tax canons, or very narrow time periods, so 5 years, 10 years, sometimes even 1 or 2 years. It's very difficult using either of these methodologies to find new canons because you need to know what you're looking for in order to hand code canons. And it's also difficult to compare systematically over time because you can't get a really broad longitudinal range of canon usage. So with our methodology using large language models, we hope to expand the scope of canon analysis. We start with Supreme Court opinion text. This is taken from the Case Law Access Project. We split it into paragraphs. And then we do multiple layers of screening for the presence of canons. So we use a cheaper model, GPT 3.5, to screen for any statutory interpretation. And then we use a multi-step process to have GPT-4 identify whether a canon is present, ensure that the canon quotation is actually in the original passage to avoid hallucinations, and then to confirm that the canon really is of general applicability. And after doing this, we produce a list of canons that we haven't clustered together in any particular way, but that we think are statements of general applicability about the interpretation of statutes. Now, the big issue when you do this kind of analysis is that you need to validate the quality of the analysis. So when you code by hand, generally what you would do is have 2 RAs code the same documents, and then you would try and evaluate what's called intercoder reliability. That's a classic method to identify the level of validity of your coding methodology. In our case, we do something analogous, but tailored for large language models. So we compare our results to the results of a study that my co-author conducted in 2016, where she hired students at Michigan to read through Supreme Court opinions and then code for specific canons of construction. This was a very careful multi-step process. My co-author personally reviewed all observations. She reread them to reduce false negatives. If the students were unclear about whether a canon was present, they would flag the issue and then discuss it with my co-author. So it was very careful and very involved. My co-author is very meticulous about making sure that no errors were made here. There are slight differences in the definition of canon we used and that Nina used in her study. So in this study, we examine all canons, which is broader, but we require them to be statements of general applicability, which is narrower. So in Nina's study, for example, the court said in one case that because the FLSA does not itself define the term outside salesman, we must look to relevant Labor Department regulations to answer the question. A statement like that is not of general applicability. It follows the logic of Chevron, which many people consider a canon, but it's not of general applicability. So that wouldn't be picked up by our study. So to make this an apples-apples comparison, we drop cases like that are not statements of general applicability. And then we also drop from the analysis any canons that are not on the list of 36 that Mendelsohn studied. So having done that, we calculate a false negative rate for her study and our study. Her study's false negative rate was 3.42%. Our study's is 1.47, which is a little bit less than half of the false negative rate by human coders, suggesting substantial outperformance. There's also the false positive rate, which is around 8%. That's a surprisingly good false positive rate, given that we were really optimizing for false negatives. False positives in this study are not as problematic because as part of the clustering step, we'll actually have a human review each of the canons that are generated. And so if any of the canons seem totally off, we can just remove them by hand. So false positives will ultimately be corrected anyway. It's really the false negatives that we need to look out for. And this validation suggests that the large language models are just as good, actually somewhat better than the humans were. So having done this, we just have this big bag of canon quotations. Well, what do we do with that? We need to extract specific canons. So we need to cluster together the bag of canon quotations so that we can see patterns in canons in general, not specific canons that only occur in specific cases. So how we do this is that we take the canon quotations, we extract a single quotation at a time, we paraphrase the quotation to extract the general statement reflected in that quotation. And then we maintain a dictionary of paraphrases with all of the quotations that fell under that canon definition. And we have GPT-4 check to see whether any entry in the dictionary matches the single quotation we're looking at now. If it does, we add the quotation to the existing entry. If there's no match, we create a new entry in the dictionary. So it seems more complicated than it is. This is really what a human would do if a human were to try to cluster a bunch of canon quotations. They would say, okay, I see expressio unius for the first time. I'll put it in the expressio unius pile. If I see another example of expressio unius, it'll go into the same pile. But oh, look, this is the rule of lenity. I'll put that in a different pile. And on until you've managed to create piles of the same canon in different quotations. We have a bunch of different hypotheses that we're going to test, but I'll just give you some initial results that we thought wouldn't be too problematic to discuss prior to pre-registration. One is just the distribution of canons. So the distribution of canons follows a log normal curve, which means that the most common canons are much more common than the least common canons. This suggests that there is a handful of canons that get a lot of airtime, and then what we call a long tail of canons that is very rare. The canons in the long tail are mentioned only once or maybe 2 or 3 times. There are statistics that you can cite about this distribution. So the top 50% of canons account for 96.4% of all observations. Top 10% accounts for 70%. The top 1%, interestingly, accounts for slightly less than 10%. So it's not just the top 1% that dominates, but the top 10% roughly is much more common. You can also express this in terms of Gini coefficients. That would be very unequal compared to, for example, national income. So it's a relatively unequal distribution. Another thing we can do is we can assess what are the most common canons. So there are classic canons that everyone knows, like expressio unius, rule of lenity, plain meaning rule, the federalism canon. These are mentioned in all of these lists, compiled by folks like Justice Scalia. There are also some canons that we found to be quite common that were not included, at least in the Scalia and Garner list. But that seems somewhat intuitive. So there's what we call the term of art canon. When Congress employs a term of art, it presumably knows and borrows a cluster of ideas that are attached. What we call the APA review canon, a specific remedies canon, an action canon. There are lots of canons that are actually kind of new discoveries that we can find because we do unsupervised identification of canons and clustering. Because we're no longer looking for specific canons, we can discover new ones and evaluate how popular the well-known canons really are. Some additional hypotheses that I'll mention that we'll test once we scale up this model. We'll identify how canon use has changed over time, what the typical justifications are for canon usage, what triggers the application of canons, Llewellyn's hypothesis, so whether canons really dual. So this is a hypothesis that for any argument, you can come up with a canon supporting either side, and therefore canons don't actually really constrain judicial discretion. And finally, we'll ask whether canons are favored by judges in a systematic way. So are there changes over time? Are there party differences? Do judges, even within a particular judge, change their preferences over time? We'll study all of this. So if there are any other feedback, items of feedback that anyone might have, any additional validation checks that we should do, any additional hypotheses that you would be interested in seeing results on, please let me know. Because this is relatively early stage, we have the ability to scrap our results, start again with an entirely new model, and we're happy to pivot. So thank you very much, and I will open it up to any comments or questions.
Yeah, thank you very much, Professors Choi, for this thought-provoking conversation. And so we're gonna enter the Q&A segment, part of the session today. So I want to launch us with a question. I think for a lot of us young scholars, we're just starting out into academia and we're putting together our first publications. So for people who are not usually empiricists, but like you have different research interests and would like to do more of an empirical studies, how did you learn how to employ these methodologies? Because as you said, they're part of the computer science literature. So how did you get into them? How did you learn which tool to use? How did you learn, for instance, how to talk to ChatGPT? I found it very amusing when you were like, well, you're skilled and you're careful and you're precious. And so how did you get to that stage, I think?
In my case, I have a graduate degree in computer science, so I started with some experience coding. But I think an SJD is the perfect time to pick up these skills. And there are a lot of people who pick up empirical chops during the course of their SJDs. So Jens Frankenreiter, Julian Yarko, sorry, they're doing construction outside. There are a lot of examples. So what's the best way to get started? What I suggest is you pick up Python and you pick a project that you're interested in. And once you pick a project you're interested in, you just figure out along the way how to write the code, ask ChatGPT for help, and having something to motivate you with a concrete task you're trying to solve, I think is the fastest way to learn how to code. And then once you learn how to code, you need to get plugged into the empirical literature. So to do really rigorous work, you need to try and attend talks if you can at your home institutions, especially if there are empiricists who are talking. What I also suggest is trying to attend offline workshops. So like this one, or the online workshop for the computational analysis of law. There are lots of ways to try and pick up fluency in these issues, and just read papers. You can even try and comment on papers and send people thoughts on the papers. People always appreciate it. Basically exposing yourself to a lot of literature and then having some project to try out empirical methods on is what I recommend.
So we've got Daniel.
Hey, first of all, thanks for the presentation. For someone coming completely from a different area, that was fascinating to hear that. So my question is kind of, so the work that I'm doing is basically old school reading of constitutional law cases and kind of trying to find patterns of ideological consistency or inconsistencies between different opinions. And what always strikes me is that it's not only interesting what the justices say at what point, but what they omit to say at other points, right? So, of course, it would be, and I would be very interested to see what kind of findings you have. It would be interesting to see that, for example, justices with a particular ideological background tend to prefer some specific canons of interpretation. But another thing that's really interesting is basically when do they decide to use that? So in what kind of cases do they use them, and in what kind of cases do they omit them? But that, of course, would kind of mean that you would have to be able to prove a negative by using your kind of methodology. And I would be interested if you're able to kind of basically do the reverse and kind of see a pattern when justices omit rules that they could have applied in the first place.
That's very interesting. Of course, the difficulty is that when you use computational methods, you need to find some way to demonstrate the denominator. So you need to find, as you're saying, the negative cases where you could have applied the canon, but you choose not to. So one proxy for this could be, as you may know, in the United States Supreme Court, there are 9 justices. They can all write their own opinions if they want to. And sometimes the majority opinion will not apply a canon, or it'll say this canon could apply, but it doesn't apply for X or Y reason. And in those cases, sometimes a concurrence or a dissent will say, hey, this other canon should apply here. And then the majority might decline to do that. So you can try and identify the negative cases by looking at the arguments made by the other justices. That, of course, doesn't always work. Another thing you could do is you could try and create a predictive model to identify cases where the canons could apply. But that is something you'd have to do canon by canon. It's computationally expensive. So it would be tough in this case. But I'm going to think about that further. That's a great suggestion.
Simon.
Yeah, thank you. Thank you. So actually my question actually was reflective of what Daniel was asking. We hosted Professor Lawrence Solom and Dean Aaron Cherminsky last year and sort of started this process of thinking about statutory interpretation and is that really a methodology itself? And we started with that question. So I guess the first question that I'm interested in kind of your opinion is, do you think about this as a rigid methodology itself after studying all of the usage of canons, or do you see some consistency on the application? Another question, and I think that's what Daniel was basically asking, is that sort of like the application of this research and situating it specifically on the Supreme Court. What these 9 justices talk about really matters dramatically, and would be interested in your agenda maybe on what are the interesting research questions that we can ask tailored to these 9 justices in your research that we can really sort of dig deeper on. Are they really using canons? Like, how do their views on canons, specific justices' opinion, how ideology really reflects on the usage of canons. So yeah, that's about it, but I have a lot more to ask. But yeah, thank you for the talk.
Yeah. So on the first question, it's a really interesting point, and I think it reflects an approach to legal studies that is more common outside the United States. So in the United States, there's a lot of enthusiasm for law and X type studies, so like law and economics, law and history. And so one of the results of that is that methodologies that are internal to law kind of get short shrift sometimes, even though statutory interpretation, for example, might be thought of as a discrete methodology on its own. So I think that's a good point. And there's the study of jurisprudence and there's the study of legal theory, and there are theories of statutory interpretation specifically that are very rich, like the legal process school. And there are a lot of legal philosophers at USC, and they're constantly like rediscovering the insights of the legal process school and saying, oh, geez, no philosopher has ever thought about this before. But like the legal process school thought about it almost 70 years ago. So I think that there's a lot to be said for that. There's one PhD program in law at Yale that I think starts to treat law and legal theory like a methodology of its own. And I think it's a move that makes a lot of sense. On the point of, what motivates judges and what methodologies they follow, that's one of the things that we're studying here. An interesting question is whether judges really care that much about methodology. So maybe it's all just window dressing and they're going to write the decisions that they were going to write anyway. And they use legal theory solely as a justification, and it doesn't causally affect the outcomes of cases. That's a relatively common view. There are ways that you could try and study that too, of course. So you could see if statutory interpretation methodology predicts the outcomes of cases. So for example, when the rule of lenity is applied, does that tend to result in the defendant actually winning more, or does the judge try and explain away those cases? There are huge selection problems with that kind of analysis. So one being, maybe the rule of lenity is never even brought up if the defendant is going to lose the case, in the opinion, that point that Daniel made. So anyway, this is like a basic question in legal theory, what motivates judges. There's a whole literature on empirical judicial thinking and judicial psychology and judicial decision making, one of my colleagues, Lee Epstein, is one of the pioneers in that field. So if you're interested in this, you basically look at any of her work and get a really good head start.
Thanks. That's very interesting.
So I'm a little curious trying to plug this project with the current political climate. Like we're at this point where the Supreme Court is gonna hear a case about Trump's immunity, alleged immunity. And I'm curious, like having such a methodology out there that could allow you to really understand the waves and kind of the trends that are appearing in the interpretation of the Supreme Court. So if you've got all these conservative judges who are claiming originalism and textualism, and with such a software, you can prove actually, well, maybe what you're saying is not really originalist. You're amounting to the decisions you're amounting to because it's political and you're being biased. So I think, do you see like a way to use this tool to kind of keep our justices in check?
Yeah, for sure. So one of the intended paths of the project is we'll investigate which canons are actually, valid, frequently used. They follow the justifications for canon use, and that would hopefully constrain judicial discretion because now a justice can't make up a new canon to support their preferred political agenda. In addition, you can see whether justices actually use canons consistently. So, will Justice Scalia be for the rule of lenity one day and against the rule of lenity another day? There is a widespread belief that justices are not really rigorous and formalist in their application of these canons, and they just use them to suit their own ends. I'm not really sure that's true. I mean, I think you see judges using them in a relatively consistent way. Justice Scalia was consistent in liking the rule of lenity, disliking certain other canons over the entirety of his career. So yeah, I think projects like these help to give shape and rigor to methods of interpretation, hopefully.
Maybe following that, I know there is like this literature about interpretation and construction as a distinction. And again, this falls into sort of the textualist approach. How does your research sort of fall into help construct like the construction zone of interpretation in any ways, or is it just unrelated? These are their theory, and it's all about canons. And also, is there maybe a possibility to I know you identified like more popular usage of some canons, but is there a possibility to evaluate like good canons and bad canons that does not really make sense at all, sort of like a normative evaluation when you're looking into the usage of canons itself?
So I think you got this from Larry Solom's lecture too, because Larry Solom loves the interpretation construction distinction. Yeah, he's written a number of papers about it. So that's a really smart point. Interpretation and construction, the general summary is that interpretation is about how to read text, so it's linguistic, and then construction is about how to construct legal doctrines from the text. So it's like a linguistic versus legal distinction. Canons can really straddle that divide. So language canons are about the interpretation of text. Substantive canons are really about construction, which is why sometimes they're called canons of construction and sometimes they're called canons of interpretation. Many people use those terms interchangeably, although Larry is very rigorous about separating interpretation and construction. People use the terms in different ways. So I think like this project does not separately identify interpretation versus construction. Can you refresh me again on the second point that you made?
It's more about the evaluation about good canons and bad canons.
Oh,
a
yes.
sort of view about all the different canons that you have to identify. Some frequently used, some less frequently used, some used in certain situations, some in other situations.
Yes, so this is really a descriptive project, and I talk about how looking at what canons are most commonly and least commonly used can provide rigor in terms of certain kinds of canon-based arguments. So one justification for canons is that they've been used since time immemorial, and everybody knows that these canons are used, and Congress expects them to be used because they're so common. For that all to be true, you would need to actually find instances of these canons' use in the historical record, and they would indeed have to be frequently used. We can test that. We can't test, on the other hand, for example, statements that are just assertions about the way that ordinary people read language or that Congress drafts statutes. So those are separate justifications for why canons might be defensible, that they're just empirically accurate descriptions of how people normally read words, or that they're empirically accurate descriptions about how Congress drafts statutes. That has nothing to do with judicial interpretation, which is what we're studying. That just has to do with people's ordinary understanding of language. And so there are alternative justifications that we can't really explore in this paper. So we try to be cautious. I don't know if we fully succeeded, but we try to be cautious and not overclaiming in this paper and not saying any of these canons that is rare is absolutely invalid. It may still be valid. It's just not defensible on grounds of commonness alone.
Yeah, because if I were using canons as a lawyer, and I know the other party is going to cite a canon that is going to be less frequently used, I would say I'm citing this paper saying that these are the frequently used canon, those are the less frequently used canon. That's why mine is more quote unquote maybe valid. That's one way. That's why I was thinking about how I can use sort of your findings in maybe in different situations.
Yeah, that makes sense. I think that's what we intend for one of the payoffs of the paper to be. And like what I mentioned as alternative justifications for canons, those have come under a lot of scrutiny in recent years as well. So there's the Gluck and Bressman paper about how all these assumptions about how Congress drafts are not actually shared by congressional drafters. So if the canons are not commonly used and they probably don't really reflect empirical realities about how drafters write statutes, what's the justification for canons? There might be nothing left.
So we've got a question from the chat from Vanessa Miller. She's interested in how, when judges use social science research in their analysis. She's asking if you can speak a little bit to how this work, if at all, includes or accounts for canons that rely on social science research.
Oh, interesting. I can't think off the top of my head of any canons that rely on social science research. So they're more often justified based on past precedent and past court practice, and not really based on research that academics conduct, for example. Now, the broader question, how do judges use social science research in their analysis? Surprisingly, academic research has become quite influential in certain areas of interpretation, and statutory interpretation is one. So corpus linguistics, for example, is a recent movement that has had a lot of success among scholars and among courts. It's a methodology of interpretation where you go back to a corpus of documents that were drafted around the same time as the statute, and you try and figure out what words mean. There's been a lot of scholarly debate over the validity of these methods, but that's an example of something that judges really are using. And there are big academic papers that are also cited by judges. So the Gluck-Bressman paper was a big paper, and it's been cited by courts as well. So this is kind of the ambition of scholars like us to have our work actually be used by courts in practice. And in areas like statutory interpretation, you can really see it.
I've got a question as a tax nerd.
Great.
I'm curious if there's any aspirations to use this type of methodology in tax. Like the first thing that came to my mind is kind of use this as a tool to check the IRS's coherence. Like if we looked at revenue rulings or private letter rulings, and we could maybe check if the IRS consistently answers the same way for the same set of facts or the same problems, if that makes sense.
Pretty interesting. So you could imagine trying to assess statutory interpretation patterns in any body of text, and that could include the IRS. So my intuitive guess is that the IRS is quite purposivist in its interpretation, for example, and you can try and test that rigorously by identifying whether the IRS is more purposivist or textualist. Or you could train a model to predict whether the justice writing a particular text is purposivist or textualist, and then use that as a proxy to score texts on being purposivist or textualist. There are a lot of interesting things you could do. So that's a good idea.
Awesome. And we have another question from the chat. So the person says, if I understand your idea correctly, the use of those canons or not comes after statutory interpretation by a judge. If this is correct, can we say that firstly, there's a place for correct and incorrect interpretation? And secondly, incorrect interpretation, can it cause the use of canons not to be used in a particular case?
I would frame it a little bit differently. Statutory interpretation uses canons as one of the tools in the interpretive process. So that might mean the same thing as what you're saying. A judge can, for example, decide whether to use a canon of interpretation or not. And then once they use it, they can use it correctly or incorrectly. There are threshold issues in interpretation. Whether to use a canon or not depends on, for example, finding a statutory ambiguity. But I would not say that canons are subsequent to or separate from the question of interpretation.
Good.
Okay.
I'm also curious about as a young scholar who wants to work on like these work on like a more empirical research within the United States. What is your advice on targeting journals, peer-reviewed or law reviews, and maybe a more long-term research agenda? How would you advise us to conduct a research agenda similar to yours, or what is your experience of building all of these projects?
If your goal is, for example, to become a legal scholar in the United States, having a mix of student-edited publications and peer-reviewed publications, I think, would probably be optimal. But it doesn't really matter that much where you want to publish, as long as your work is good. So maybe the better advice is to write the kind of scholarship that suits you, and then publish it in the best journals that you can, basically. So if you like shorter scholarship, then peer-reviewed publications might be the way to go. If you have really big ideas that take up lots and lots of pages, maybe student-edited journals are the way to go. Some scholars don't like student-edited journals, but I think they're great. Students do a lot of good work in making things ready for publication. And it's much less taxing to submit to a student-edited law review than it is to submit to certain kinds of peer-reviewed journals. So I would say both are routes to academia, and you shouldn't feel pressured to publish any particular kind of scholarship.
Thanks.
Daniel.
Hey. So my question goes back more to to the substantial question of the piece, and really comes from a deep legal realist skepticism with a lot of the discussion so far. So I just want to kind of clarify. The question is basically, what are the outcomes of your research, or kind of the purposes? Because I see like 3 ways to read it, and I would be interested in how you would approach these 3 different ways of reading it. So the first one is, of course, purely academic. That is, easy. It's just interesting to see what the court does, right? Just as legal scholars, that's just interesting. That one seems very easy to me. The second one is if you're someone who's trying to make arguments before the court, right? And if you make arguments before the court, it might be interesting to, for example, know that Scalia, he's not a justice anymore, obviously, but let's say Kavanaugh is extremely receptive to a certain kind of canon. I, as a lawyer, might expect that Kavanaugh might be the tie-breaking vote here. So I want to give him some kind of possibility to use this kind of canon because I know he's receptive to this. And there are 2 ways to think about this. So the first one is just purely instrumental. I personally think that Kavanaugh is going to decide what he wants to decide anyway, but I want to give him the opportunity to have some kind of legal framing for what he was going to say anyway. And then, of course, there's the other ways to think about this is I can convince him by making this argument to make him this is the real, true legal outcome. Okay, that's the second way to read your research, is basically an instrumental one. And this leads to the third one, which is the one you were kind of discussing with Simon before, is building up basically kind of a correct reading or restraining justices in what they are able to do. And that kind of threw me off a little bit, because it seems to imply that justices are kind of bound by previous use of their own methodology. And if that would be the case, that would probably also mean that originalism can't work as a methodology, because originalists would have to recourse to the methodology of the 1970s Warren Court. So a true originalist justice then would have to do purposive reasoning, value-based reasoning from the Warren Court era, because that was the kind of proper judicial methodology that was used before, and kind of using the kind of canon that previous justices have used. So the kind of, I mean, there's no stare decisis or methodology. There's only stare decisis for substantial questions, basically, right? Okay, yeah, that was like a lot of thoughts out there, but I just put it out there.
Great. So this is great. And this is one of the fundamental issues with canon-based reasoning and with interpretive stare decisis, as you're saying, in general. So you can be an originalist and believe that canons have validity because they were used in 1789, and be indifferent to how canons were used in like the 1970s or how they're used today. So that's one of Scalia's justifications for why the rule of lenity is valid. Even though it's stated nowhere in the Constitution, he believes that it was implicitly adopted because it's been in place so long. And so one of the justifications for these canons of interpretation is that, for example, if a statute is written, this is kind of an originalist point. If a statute is written in 1950, what matters is whether the canon was frequently used in 1950. And then if since then, from the 60s to 2010s, nobody used it, an originalist might say, it doesn't matter. We still have to read it with the rule of lenity in mind because it was used as of 1950. Obviously, there's a big question whether interpretive methodology constrains justices at all. I think there, like the legal realist, the critical perspective is that no, justices are just instruments of power or whatever, and that they decide cases based on pleasing the president who appointed them, or being popular at cocktail parties, some other grounds. I do think, insofar as courts create interpretive trends, even though there is no such thing as methodological stare decisis in the United States, you can see very strong patterns of lower courts following the methodological approaches of higher courts, maybe because they don't want to get overturned on review, but maybe because there's just norm following and norm creation in interpretive methodology. And so you see the pattern of Justice Scalia becoming a textualist, then all the appeals courts become textualist, then all the district courts become textualist, and there's a cascade. And I think even if the Supreme Court is being instrumental and not necessarily being interpretive methodology first, so maybe if it is favoring certain substantive results, on the district court level, you see a lot of, I think, a relatively rigorous application of methodology, because the district court justices don't feel that they have the same freedom to kind of make new precedent and make new policy. So even if you're a realist for the Supreme Court, you might not be a realist for the district court or the appellate court. And there's a lot of action at the district court and appellate court. So even folks who are dubious about the Supreme Court might think that methodology matters.
We've got a question from Napas Kamal.
Yes. So we talk about like how our large language models are used by other like legal professions, but do you think like they should be implemented by judges, and to what extent?
It's really interesting. Yeah. So I am teaching an AI seminar right now, and that's going to be our last topic of discussion this semester, AI judges. So AI judges and AI arbitrators, because a lot of adjudication actually happens in the form of arbitration these days. You can imagine a judge as a kind of predictive model. So you see this most clearly in, for example, sentencing guidelines or parole guidelines. Sometimes sentencing guidelines have judges evaluate the risk of recidivism. So if you have a criminal who commits a crime, what's the risk that they're going to commit another crime again? And if they have a high risk of recidivism, sometimes sentencing guidelines will say the judge has to give them a harsher sentence. So in cases like that, if the judge is conducting a purely predictive role, then AI might be able to do a better job than a human judge, and at least a more consistent job, right? Because judges are individuals, they may have separate views, so it might be unfair that if you get a tough judge that you get a longer sentence. And there are a lot of biases that judges have that might actually be easier to root out of an AI model. So you can assess relatively straightforwardly whether an AI model is racist. A judge will never admit to being racist. They'll just say, oh, I'm tough on crime, whatever. So there are several advantages purely from a predictive perspective of using AI models instead of human judges. On the other side, there are a lot of things that judges do, of course, that AI is not well situated to do. So just courtroom management. Someone makes an objection, the judge has to decide whether the objection is sustained. The human element of making sure that the trial runs smoothly, of conducting fact-finding in particular ways. This is especially true with respect to arbitration, because arbitrators are really fact-finders, and so they do a kind of investigation that currently large language models cannot do. So all this is to say, I think there's promise with respect to purely predictive tasks in using AI models to at least complement and maybe replace judges. But it turns out that that's a very small percentage of the actual job of a judge. So you could imagine that there's a role for both.
Okay. Well, if nobody else has any questions, I see that we've almost run out of time, but before I let you all go, if it's okay with you, Professor, I want to ask those who can to turn on your cameras, and if we could take a group picture to memorialize today's insightful conversation. For those who can. And Simon, would it be okay for you to screenshot?
Yes.
You're our
yeah.
cameraman.
I'm trying to make sure I'm not for some reason you're logged in. Oh, okay. Now it's good. All right. Well,
Give us the countdown.
yeah, okay. All right. 1, 2, 3. Fantastic. Let's take another one. 1, 2, 3. Fantastic.
Awesome.
Thank you so much, Professor, for discussing your research with us.
Thank you, guys. This was great. And good luck with your research. And if anyone has any questions, feel free to shoot me an email.
This is amazing. And thank you all for joining. We'll be having a lot of interesting sessions for this year, so we hope to see you all soon. Thank you again.
Thank you.
Thank you. Take care.